Move to the second case on today's docket. Jackson versus the State of Florida.
Good morning. May I reserve 5 minutes, please?
Certainly.
May it please the court. I'm Karen Moore, and Thomas Varosik and I represent Kim Jackson. We're here today to discuss the guilt phase issues raised in the appeal after the circuit court's denial of our motion for post-conviction relief. The circuit court found deficient conduct by trial counsel on the handling of the DNA evidence in this murder trial. However, the court did not find that the prejudice rose to the requirement by Strickland. The circuit court misapprehended our argument on this, and I'd like to talk about the DNA evidence and other issues in the case. The case consisted of a hair found on the victim's leg that was determined to be a full marker DNA match with Mr. Jackson, a fingerprint and blood on the lip of the sink, and his denial of ever having been in the house or known the victim as Pearce. The hair on the victim's leg, the defense tried to argue that it was innocently transferred. And in JOA, they argued that it could have been come in through an open door, people passing by. It could have happened in innocent ways. The circuit court said, give me a reasonable reason. If counsel had retained a DNA expert in a timely manner, instead of about 5 weeks out from trial, and had counsel met with the DNA expert, had her examine all the evidence in the case, had her available at trial, the DNA expert could have explained that hair has such a low priority level in testing in the DNA labs because it is so easily transferred. And the DNA expert could have explained to the court, and most importantly, the jury, that the hair could have been there quite innocently.
Counsel, can I'm going to ask a question about that.
Sure.
It's my understanding, kind of looking back at the transcript of that hearing, that your experts in the post-conviction phase did not refute any sort of claim from the original trial regarding the 34 nanograms that was on that hair. So is there any point that I missed or anything in the transcript in which your experts said naturally shed hair can result in this many nanograms of evident DNA being in a hair versus something that's not naturally shed?
My expert said that she had obtained a full marker profile from a naturally shed hair. And the DNA analyst said she had, I believe, between 30 and 35 nanograms in the sample from this hair. My expert also said that at the time of the testing, the study was done in 2001, which counsel wasn't aware of. But at the 2006, when this testing was done, a full marker profile could be obtained from a single nanogram. And a nanogram is a billionth of a gram, so we're talking about incredibly minute, not visible to the naked eye evidence here. So she's talking, Ms. Clark is talking about 30 to 35, and my expert is talking about 1 to 10 nanograms. So in the scheme of things, we're talking about a difference of 20 billionths of a gram, and it's not much. But the whole point of this is, and we didn't argue that this wasn't Kim Jackson's hair. Mr. Jackson had testified that he'd been in the house, he'd moved a couch, and he'd been up under the sink repairing the garbage disposal. So what the argument was that this hair could have been there and easily transferred, but the circuit court did not accept that argument and was rather dismissive of the argument by counsel at JOA. So we didn't argue it wasn't his hair. We were saying that it could have been naturally shed based on our expert's own experience, and based on the fact that you could get a full marker profile from a single nanogram, a single, billionth of a gram.
Did your expert say that hair with the 34 nanograms could have been naturally shed?
Yes, she did. She did. But the hair isn't the worst part of this. The worst part of this is, well, there's another hair that's bad, but the worst part is that the state put on Detective Waldrop in rebuttal to state that the victim's van was found on the same road where the defendant lived, about a mile or a mile and a half down. And in closing, the state argued, there's the van, the victim's van, there's her blood, there's a mixture there. The DNA analyst says that the defendant matches at a couple of those markers. And the point was to put the van close to the defendant's home. Chester Nardvell, the friend of the victim who found her body but had noticed her car gone a couple of days before, that was important because the state argued that the van went missing at the time of the murder, and they connected Mr. Jackson to the van with this evidence of he cannot be excluded. However, the report that was vetted by FDLE, by another examiner and a technical examiner, and Ms. Clark had testified that every word she wrote, every test she did was reviewed. The problem is that she said, I could not determine the profile of the minor donor. Had counsel had a DNA expert there, the DNA expert could have explained to counsel, look, she's just testified beyond her report, and not only that, and the two experts we called were both former FDLE examiners, and they have guidelines, and they cannot include an allele or a peak that's below a threshold. They can exclude for that because the power is exclusion, but they cannot include. And when she said, I cannot exclude Mr. Jackson at the Y marker or at two others, which came up on cross and then on redirect, she was saying, I can include him. And that was very critical evidence for the state because the state wanted to put Mr. Jackson in that van. The state had a problem. There was a third hair that was found in the victim's hand. They bagged her hands at the scene to preserve evidence. There was a third hair that had an extra allele. Major donor, again, was Ms. Pearce, but there was a minor donor, an allele, that did not match Mr. Jackson. Add that to the fact that the DNA on the tip of the knife that Ms. Pearce wielded had DNA from at least one male, maybe two, that Mr. Jackson was excluded from. And then you've got a real reasonable doubt argument. And the problem is counsel did not even talk to the DNA expert they retained until the day before trial, when she had not even completed her examination. They had no intention of calling her at trial. They were just checking a box. I talked to the DNA expert. She couldn't help. So it was deficient conduct. The court found that, but it was also very, very harmful because the defense could have rebutted the DNA expert's testimony that this was, Jackson's DNA in the van that was stolen the night she was murdered and found near his home, and also excluded him because Ms. Zuleger, our expert, said, look, you can go below the threshold to exclude if you believe that it's a peak, if it's a peak. And Ms. Zuleger excluded Mr. Jackson at the VWA marker and I think one other. So this was important. It could have cast doubt on her other testimony too, frankly. And it's concerning, again, I mean, she didn't do other things. She didn't run the second required test by CODIS of the co-filer. She said she'd followed all the rules, but she didn't. So, it could have cast doubt on the fact that this was a forcefully shed hair. Had the DNA expert been available, had they utilized this expert. And when I asked Mr. Bate at the evidentiary hearing, could a DNA expert have helped explain to you the ease of transfer of hair or the low value of testing hair at a crime scene? He said, well, I don't know if she knew about it. He obviously didn't know about it. So, the court and the state argue, well, it's not, we'll excuse this because, maybe he didn't want to bring up something on cross when they were getting some good information from her. But they didn't even know about it. So that can't be a valid strategy call. They didn't know about that. So the DNA was huge. And the DNA evidence is very daunting. You have to study it. In this case, the first defense team requested the lab notes, something beyond the mere report, the electronic data in January of 2010, and it was ordered disclosed in January of 2010. When Mr. Bate hired this expert, he sent her the latent print reports 2 different times, and it wasn't until April 4th, and we're 11 days out from trial, when he finally gets the records that his expert had requested. And his expert said, again, it was wrong for Ms. Clark to testify below the threshold to include Mr. Jackson in the blood on the steering wheel cover. Let me talk about the alibi, too, because the jury came back with a question about the alibi.
I'm sorry. I was going to ask you about the other fingerprint, the fingerprint
Sure.
on the sink. You can do alibi first, or since we're on the subject of fingerprints, would you like to do that?
I can talk about the fingerprint.
Okay. Let me hear what you have to say about issue 2, please.
The fingerprint. A couple of things. The defense counsel opens in his opening statement and says, look, you're going to hear that this fingerprint is not of value for comparison purposes. And in the literal next breath says, but it's her fingerprint. Then he calls the witness in his case. And again, he has her testify that the print is not of value for comparison purposes. On cross-examination, that witness becomes another state witness because the state asks the witness to look at the side-by-side photos that have been enhanced since she last viewed them, and now she cannot exclude Mr. Jackson from that. The state put it best in closing that it was the most wildly confusing thing. Was it not of value or was it his print? And other bad evidence came from that. The state then did the reverse vouching, said, I know this examiner and she's a great woman, but she's just dead wrong on this, and intimated that he had, information outside the record about her and why she shouldn't be believed. And this court had a problem with that on the direct appeal. And the fact that the print is there, Mr. Jackson admitted being in the home. His print was there. I'm not contesting that it wasn't his print, but it doesn't mean that he killed this woman. There's more proof that the DNA from the unknown people on the business end of the victim's knife killed her than anything else. So,
But counsel, it wasn't just a fingerprint.
It was
correct?
a fingerprint and blood.
Right. And wasn't there, there was testimony that is not just, blood doesn't just appear on fingerprints. It's usually made
Well,
with the bloody fingerprint.
the
Blood
FBI.
on the finger.
I'm sorry, I didn't mean to.
No, that's okay. Go ahead.
The FBI agent said she'd never seen it, but it was possible. But it could be that Mr. Jackson was at the scene at some other time, even after, and touched that. But it doesn't mean that he killed her. It does not mean that. And there's more evidence. The third allele of the state described a violent struggle with pulling, and there's a hair in her hand that has an allele that's not hers, and it's not Mr. Jackson's. Same thing with the knife that she wielded. So it was important. And the defense the defense was so disjointed, it argued contradictory theories on that, and it was confusing, and Mr. Mizrahi put it best. It was wildly confusing. Let me go to the alibi. The jury came back with a question about, and counsel had advised their witnesses not to tell the jury that the reason they believed that this was Mr. Jackson's weekend up about his birthday was because that was the last birthday they saw him as a free man. So at that point in time, the murder occurred in 2004 and the trial is in April. So this alibi is already 9 years old and it's very stale. And these witnesses, friends, family, were predictably impeached with their affection for Mr. Jackson and their uncertainty about the time. But if counsel had spent any time with Penny Williams, they would have learned that Ms. Williams, Mr. Jackson's sister, had very unique personal reasons to remember this date. Shortly after her brother left from his birthday celebration in Adel, Georgia, she lost her job. She had 3 kids, and it was the first Christmas she had not been able to provide gifts for them. She was embarrassed that she had to ask her father for help for gifts. She also met her future husband a couple of months later in February of 2005, and she married him in April of 2005. And those are dates that she knows. They're very unique to her and very personal to her and to her husband, and that was never developed. So you have this very vague recollection of something that happened 9 years earlier around his birthday. The other problem with the alibi testimony provided was that Debra Jackson, Kim Jackson's wife, testified. And first question on cross-examination is, have you ever been convicted of a crime involving dishonesty? And she said yes. At the evidentiary hearing, I asked Mr. Perkins, who conducted the direct on her, I said, why didn't you get up there and explain the circumstances behind this worthless check? And he said, well, I could have. He had no reason. There was no reason not to do that. So there's no valid strategy call there. But he could have put her, or conducted a redirect examination and asked her what happened with this check. It was a single check for about $50. It was 20 years before her testimony. And she
Counsel,
was,
I just want you to be aware you are consuming your rebuttal time here.
anyway, she was a compelling witness. She could have explained that she had just missed this. She'd lost a child. And the jury had very much interest in that alibi defense. They were considering it. They wanted to know about it, and they wanted that testimony read again. I'll reserve the remainder of my rebuttal time. Thank you.
May it please the court, my name is Jason Rodriguez, Assistant Attorney General for the state of Florida. In my time before the court, I'll explain why the post-conviction court correctly denied Jackson's 3851 initial motion on his guilt phase. Before reaching the substance of anything, I did want to address Justice Groshand's question to opposing counsel early on regarding the 34 nanograms of DNA. And at no point in the evidentiary hearing below did any testimony come out that a naturally shed hair could contain 34 nanograms of DNA. The testimony was that 1 to 10 nanograms could come from a naturally shed hair. That was from their expert, and Ms. Clark agreed. If this court is more interested in that issue, the record cites for that are pages 2,391 through 98. I believe that's their expert testifying. Then regarding the 34 being beyond what a naturally shed hair would have contained, record at page 2,446, 2,489, and 2,519 through 21. There was no dispute that a naturally shed hair could not contain that amount of DNA. If it was naturally shed, it had 1 to 10 nanograms, and Ms. Clark says that's on the high end. 34 nanograms is not in that range. Regarding the remainder of the arguments that were presented here, I did want to focus the court on two legal principles at the outset. And the first one I think is probably best put by the 11th Circuit case of Putman versus Head cited in the briefs, and that's that if the record is unclear or incomplete about why counsel took the actions he took, that's when the presumption of competence attaches. And the 11th Circuit went on to say that the presumption afforded to counsel is not what a particular defense counsel in reality focused on and then deliberately decided or not to do or not do. Rather, the presumption is that what the particular defense lawyer did at trial, for example, what witnesses he presented or did not present, were acts that some reasonable lawyer might do. That's why, when it is unclear why counsel took the action he did below, counsel says a couple times, I don't remember why I didn't redirect Deborah Jackson. I don't remember why I didn't bring this out from Penny Williams. This court is required to, under the Sixth Amendment and under Strickland, to indulge in a presumption of competence. Could a reasonable lawyer take that action as strategy? And if they could, that's the end of the inquiry. The second...
What about the evidence that there was DNA from two other people on the tip of the knife?
Well, Your Honor, that was actually brought out by counsel. As far as the pocket knife that was found beneath Jackson, the victim, that pocket knife was found beneath her, and that was the evidence that Jackson's trial counsel argued and said that was the best evidence I could hope for. The state's expert is telling me that there is DNA that matches neither Jackson nor the victim found on a pocket knife beneath her.
And was that used extensively in closing?
Yes, Your Honor. Jackson's counsel argued that this was the person that did it and said maybe it was the people that came in afterwards that were looting the house. But yes, that was argued in closing. That was Jackson's theory of the case.
So what would you consider to be the best evidence there is to support the state's position that this defendant did it?
The bloody fingerprint. Because particularly, and this court noted on direct appeal as it recited the facts, that although the FBI experts said that she'd never seen it, but it was possible, that I believe it was William Shade concluded the sink fingerprint matched the ring finger of Jackson, and the fingerprint was left on the sink while Jackson's finger was coated in a wet substance such as blood. This is not a situation where he was there a couple months before and left a fingerprint that was later coated in blood. It was a situation where he touched that sink while his finger was coated in blood. So that ties him specifically to the murder. Obviously, that goes in tandem with his denial that he ever knew her, that the jury heard, and that he'd ever been in her house, which is the first thing that he told investigators when they went to speak with him. The second principle that I do want to direct this court to is that a 3850 motion really confines what we discuss, both at the trial court and on appeal. And Penny Williams' name is not mentioned in the 3851 motion. It's not mentioned, her testimony is not mentioned in the 3851 motion. And so there can be no claim that is properly presented to this court regarding what she said or did not say. This court is bound and has recognized on multiple occasions, if it's not in the 3851 motion, we don't consider it. So with those claims in mind, I did want to proceed more directly, or those principles in mind, to talk about the specific issues in this case. The first being the blood on the steering wheel, and this misperception or mistaken statement that by saying that there's potential male DNA there, that Clark testified she could include him. Clark's testimony was very clear that the results of her testing regarding the minor donor with the DNA on the steering wheel was inconclusive, and the trial court recognized that. And to the extent that Clark even hinted that I can include him, the state didn't recognize it, because in closing the state said, Clark can't even say if it's male or not. So there was no remote indication in Clark's testimony that she could include Jackson by her statements. She was firm all throughout. That is an inconclusive piece of DNA. I cannot utilize it to include or exclude. And Clark also mentioned that the modern way that FDLE has shifted and the testing has shifted is that we don't use what's noted as the star ones, where we exclude for something a lower threshold than we would include. So it's the same analysis on both fronts on the current time. Regarding the allele that their expert below Zilliger used to exclude him, Clark testified it was in the stutter position. I wouldn't have used it. And so we had a situation where what counsel would have found would have been disputed evidence, whether he could be excluded or whether the results of the blood on the steering wheel were inconclusive. And that's important because counsel had a specifically articulated strategy in the record on pages 2,312 through 15. And that strategy was, I'm not going to attack what Clark does as far as her testing, because she has given me the best piece of information that I could have, someone else's DNA on that pocket knife. So to the extent that in post-conviction, Jackson is claiming counsel should have done all of these other steps that would have directly gone against the strategy and the reasonable strategy that he had, his ineffective assistance of counsel claim fails. Regarding the ease of hair transference, this court has thoroughly rejected that in Reed v. State. It bears really no greater mention than that. The other DNA piece of evidence was what was termed incorrect testimony from Clark regarding the hair that matched neither Jackson or the victim, according to post-conviction counsel. Clark talked about this hair. There were 10 hairs apparently found in the victim's hand. All of them matched the victim except for one. That's undisputed. There is one that is a disputed hair that contains a singular allele that their expert said below it matches neither Jackson nor the victim, and so the postulation is that belonged to some other party. The issue was, again, this would have been disputed at trial. Clark, in her testimony, said this allele is a Semitic point mutation. It's not an uncommon occurrence, and all of the other hairs, they looked alike. There was no way to distinguish them. So in reviewing everything, I labeled this as inconclusive because I know about this phenomenon, and that's what I would have told to the jury. So we again have a situation where counsel could have gone against his strategy, created a battle of the experts on this hair, or he could have done the more reasonable thing that he did do, which is focus on the pocket knife beneath the victim that had DNA that no one disputed belonged to someone other than Jackson or the victim. I did want to very briefly on this issue, the trial court made a very generalized finding of deficient performance that seemed to be based on a frustration with defense counsel that they did not contact a DNA expert sooner. But this court owes the trial court no deference when it comes to a determination of deficient performance. That is reviewed de novo. The underlying facts are for competent substantial evidence. And there is no Sixth Amendment time frame that requires a defense counsel, any defense counsel, to contact a witness within a given point of time, and that appears to be what the trial court's frustration was. Counsel did indeed contact a defense witness on the eve of trial, gave her the evidence that was needed, incorrectly gave her the evidence on one occasion, but her ending result was, I found one piece of important evidence, DNA on the pocket knife, that counsel already knew about. So counsel didn't deficiently perform by, in fact, consulting an expert, a DNA expert, who was of no help to him regarding any of his strategy and told him what he already knew. There is no Sixth Amendment clock that suddenly stops and requires counsel to perform things in a certain way when there is nothing beyond that. Regarding the fingerprints, there is a claim raised that there were contradictory claims about the print. They presented Royal as the fingerprint examiner who said the print is of no value, but also conceded both in opening and closing that this print belonged to Jackson. The trial court explicitly found a variation of this claim was waived below. Because it was not raised in the 3851, it was raised for the first time in closing argument. And I say a variant because the argument that was raised there is that counsel was ineffective for presenting Royal and then conceding in closing argument that it was, in fact, Jackson's fingerprint. It is morphed now on appeal to counsel was ineffective because presented Royal and now in opening and closing, it was conceded that it was his print. This court does not permit claims to morph mid-appellate process or for them to be presented for the first time in closing argument. The failure to object to the state's comments about Royal in closing, counsel had an answer for that, and the court found that that was a reasonable strategic decision because counsel was okay with the state partially vouching for a defense witness. It's the bottom line. Counsel had a very unusual situation with this fingerprint expert. This appears to have been the only fingerprint expert that came to the conclusion that the print was of no value. Counsel had consulted with a fingerprint expert, and in post-conviction it came out that individual was of no help to him. So counsel had this piece of evidence that was contradicted by a lot of other evidence. It makes sense for counsel to not put his credibility behind this singular witness that would have contradicted the FBI, the state's other examiner. but at the same time having a desire to just place that before the jury and see what happens. See if maybe one juror thinks that that's reasonable doubt without putting his credibility at issue before the entirety of the panel. That appears to be what counsel did in this case. I can't give you counsel's exact reasoning because since it wasn't presented in 3851, it wasn't delved into at the evidentiary hearing either. So this really ends up looking more like an ineffective assistance of counsel claim on the face of the record than anything else. That particular one does. Let's see. Regarding the investigative alibi situation, again, the trial court seemed to have a general frustration that counsel did not go and consult these alibi witnesses at a better time frame. That's simply not the standard for ineffective assistance of counsel. The Williams claim we've already partially discussed is not referenced at all in the 3851 motion, and it is improper to go and discuss it beyond that. It's a waived claim if it's not raised, and at minimum, as this court noted recently in Brown, when you have a failure to call witness claim, you have to name the witness and what they would have said. And that's citing Booker, which is a much older case.
Could I ask you to go back to the alibi, which you pretty quickly through? Does the state have a position on whether there could have been any strategic basis for not conducting the alibi investigation in a more timely fashion?
So counsel gave a reason to that below. He said, I knew the alibi was stale by now, that it was an old defense, and so it was a low priority, was in a nutshell what I took his reason to be. But he did send investigators out. He did, in fact, present a fairly comprehensive alibi defense. If his alibi witnesses were believed, they placed Jackson in Georgia from October 15th to October 22nd. The murder occurred on October 17th, so it would have been midway in between those two dates. So it's difficult to determine how counsel could have presented or investigated an ineffective alibi defense when he actually presented a decent alibi defense that simply couldn't overcome the fact that Jackson had touched the sink above the body of the victim with his finger while it was coated in blood and left a mark behind him. So that appears to be the strategic reason. I have other things to do. I don't have the time to deal with this old alibi defense, but I will do it. And he did, in fact, investigate it and put on a substantial alibi defense. Regarding the failure to prepare the wife to testify, it's unclear what counsel could have done as far as the delving into more of the details of this. He could have brought out the facts that post-conviction counsel suggests, but that's a normal strategic reason. The trial court pointed out that it's strategic not to point the jury more closely to the fact that this individual has a misdemeanor conviction. And I do want to hone in that if counsel would have presented exactly what the witness said below, Deborah Jackson said below, it was a 20-year-old conviction and I just missed it. Well, she didn't just miss it. We don't convict people for just missing checks. The statute that has been in play since the time period that she's referenced requires a mens rea of intentionality. So if she verbatim said what she said in post-conviction, the state's next step would be to admit a certified copy of the conviction and discuss what it would have been required to prove to get that conviction, including that she intentionally lied about her checks. And if she was willing to lie about that, wouldn't she be willing to lie to save her husband's life? Get him off on a first-degree murder charge. That would have been the picture the state could have depicted if she testified exactly the way that she did in post-conviction. And that's simply a reasonable strategy for counsel to avoid delving into things of that nature. I did miss on the issue 4, the investigate the alibi defense, the last birthday before prison. In my review, that's also unpreserved, but it also makes perfectly reasonable sense why counsel would not have wanted the jury to know that Jackson was going to prison right after this time period where the state's accusing him of first-degree murder. That's very different than learning that he's a convicted felon at some unspecified point in the past. Learning that you are at this point in time, admittedly, committing crimes that are putting you away for a long period of time while the state's accusing you of first-degree murder is just vastly different. And at minimum, a reasonable counsel could have perceived it that way, and this counsel, in fact, did perceive it that way. Your Honors, as Justice Coriel reminded me last time, I need to invite the court to, if they have any more questions before sitting down. And so if the court has any more questions, I'm more than happy to address those at this point. Seeing none, the state respectfully asks that this court affirm the conviction that has been entered in this case. Thank you, Your Honors.
Thank you, counsel. Rebuttal.
Had counsel presented a full alibi defense, the witness's testimony would have been boosted, their credibility would have been boosted, and this likely would have been a different result. The offer of strategy for not talking to Deborah Jackson or not doing the redirect can't be provided at the evidentiary hearing or in the court's order denying by the court or by the state when counsel didn't even consider it at the material time, and that was at trial. Strickland says that we can't look at these cases through the distorting lens of hindsight. Well, neither should the state be able to provide strategy reasons for counsel who did not even consider this evidence at the time of trial. And I'm talking about Clark now, Lee Clark now. The state suggested that, hey, maybe you didn't cross-examine Ms. Clark because she gave you helpful information. Well, that's not why he didn't cross-examine on the mixture on the steering wheel cover. He didn't know that she was testifying beyond her report, and he didn't know to contest that. And the state can't now provide a valid strategy reason for that. And just one more thing on the hair. The Ladd report, and it's in evidence, I think it's on page 1212 of the record, it says typically you'll find 1 to 10 nanograms. And again, we're talking about billionths of the gram. But the whole point about the hair was that it was easily transferred, and counsel missed an opportunity to have an expert come in and say, look, we don't usually test this stuff because it's so low in relevance, because it is so easily transferred. So the state and the circuit court shouldn't provide strategy calls that didn't exist in the mind of the lawyers based on thorough preparation at the time. This was not the guiding hand of counsel contemplated in Powell v. Alabama through Strickland through our current jurisprudence. We do not have to prove that not one reasonable lawyer would have done what these lawyers did. We have to prove that there was deficient conduct, and we have to prove that the deficient conduct undermines your confidence in this verdict, and we've done
Counsel,
that.
you have exceeded your time, but go ahead and sum up in about 30 seconds, if you would.
Sir, I would just ask you to reverse the circuit court's opinion and remand this for a new guilt phase. Thank you.
All right, we thank you both for your arguments. The court will be hearing